Good afternoon, ladies and gentlemen, and welcome to this online event entitled Ensuring Europe's Patent System is Fit for Purpose in the Digital Age. I am your moderator. My name is Paul Meller. I'll talk you through a little bit about how this is going to work. The event is basically divided into three sections. First of all, the academics that were put together the report will present their report. We'll have Q&As to them. We'll then have a panel of experts from industry and legal experts. And there will be another Q&A after their interventions. And then we will have an intervention from the European Commission from Amaryllis Verhoeven, whom many of you I'm sure know, who's very active in the field of patents at the European Commission. There will be a Q&A after that as well. So that is the broad structure of the day. I just want to say that the process of submitting questions, because this is an unusual situation, we would have preferred to be able to just see hands in the room, but we're going to take questions either through this Vimeo feed or through our Twitter feed, the hashtag, which should be on your screen, #PatentsForDigital. So you can submit comments and questions through both channels, and we will prioritize questions. And with no further ado, I will pass you over to our host from IP2Innovate, the Executive Director, Patrick Oliver.
Thank you, Paul, and a very warm welcome to you all. I'm delighted that over 180 people are attending the event today. We have representatives from Asia, North America and Europe, and you represent over 70 different organizations. We have representatives from the European institutions, national governments, national patent offices, the judiciary, the legal profession, academics, industry, and the media. And the fact that all of you are here today, I think, is testimony to the importance of the topic we are discussing. And I'm particularly pleased that we have representatives from a wide range of different organizations representing different views today. The topic, ensuring Europe's patent system is fit for purpose in the digital age, is a critical issue to ensure that companies can innovate and attract the investment they need. And never more so given the public health and economic crisis that we are in. 2 weeks ago, when Commissioner Thierry Breton addressed the European Parliament's Legal Affairs Committee, he understandably spent much of his time discussing how to respond to the coronavirus. Yet he stated that his first priority is to create a single European patent, and a patent framework that is more adapted to the challenges of the digital age. Patents and the coronavirus are not unconnected. The need to adapt the current patent system predates the current crisis, but it is all the more pressing because of it. Innovation is helping us cope in the short term. Think of the proliferation of remote working tools such as the one we are using today. But more important, innovation, including digital innovation, are vital to help us navigate our way out of the crisis. For companies to be able to invest and develop new products and services and offer them on the market, the need to know that the patent system supports rather than hinders their efforts. This is the primary purpose of IP2Innovate and the organizations that are supporting the event today. We are all concerned about a number of imbalances in Europe's patent legal systems that are being exploited to the detriment of innovation and growth in Europe. The exploitation of these imbalances is in particular shown by the rise of litigation involving patent assertion entities in Europe. These patent assertion entities are also known as non-practicing entities and sometimes referred to as patent trolls. They present roadblocks and seek to remove products from the market at a time when Europe should be making it easy as possible to bring these innovations to market and to ensure access to the technologies that we all increasingly rely on. So today we'll hear from a number of companies from different sectors that will provide examples of how these imbalances are impacting them. And as Paul's already mentioned, we'll hear from Professor Sturzi, who will present the findings of his landmark study on non-practicing entities and how they are taking advantage of certain features of Europe's patent system. IP2Innovate believes that there is a simple but effective solution to this problem, and that is to ensure that the rules on balance, fairness, equity and proportionality that are set out in EU law, that these rules are effectively and consistently applied across Europe. So before we hear from the various speakers we have today, I would like to invite Marianne Walsman, MEP, to say a few words. And thank you very much, Mrs. Walsman, for supporting the event today.
Dear ladies and gentlemen, it is a great honor and pleasure to have the possibility to welcome you to this event. The digital age has brought us many challenges, but also opportunities. The existing regimes have to undertake a test if they are still fit for purpose in order to cope with the digital age. Is the existing EU's intellectual property regime still fit for purpose? Well, I would say that we need some adaptations, but I would be interested to know how you would reply to that question. As a rapporteur on the report on product safety, I had to deal with the safety aspects of products embedding new technologies like AI or robotics. It is not easy task since products become more and more complex. This also represents a challenge for Europe's intellectual property system and the patent system in particular. Complex high-tech products may be covered by a large number of patents, and even an accidental infringement of just one patent can result in an entire product being removed from the market. I followed a systematic approach on the European product safety legislation, and I think that my approach can even be transmitted analogously to the intellectual property regime. That is why I would suggest to, firstly, identify the new challenges that the current intellectual property regime faces. Secondly, to identify the existing gaps or the problems in the existing legislation. Thirdly, to close only those gaps in order to prevent over-regulation or to solve the existing problems. The existing problems concerning the framework for intellectual property might even be its application across the EU single market. Intellectual property rights such as patents are crucial to support creativity and innovation. But a healthy European patent system has to, on the one hand, be strong in order to protect innovations, and on the other hand, it should not impede the access of new products and services to the European market. This balancing act is a key for a competitive and innovative single European market. We need an efficient system in order to reach our ambition of becoming a world leader in new technologies, such as AI and blockchain. How to turn this theory into reality in this challenge? I'm quite sure some of you have helpful ideas on that. I am in particular curious to know more about the study and to get your input on how the patent law can be adapted in order to enhance and incentivize investment in new products, but at the same time to enable new products and services to reach the public. We politicians need your concrete proposals in order to make good practice-oriented legislation. So please help us to create an efficient and balanced patent system for the benefit of a competitive and fair single European market. Be sure that even though I have to leave this event just after my welcome speech, my assistant will stay with you and brief me afterwards. Thank you in advance for your understanding and thank you for your attention.
Thank you very much, Mrs. Walsman. We're now going to turn to Professor Sturzy, who is going to give an overview of his paper.
Nice to see you, Paul.
Yes. You're going to be giving a short presentation about your paper. Professor Sturzy is an associate professor at the University of Bordeaux, and his new paper entitled Non-Practicing Entities and Transparency in Patent Ownership in Europe is certain to raise a lot of eyebrows, and we hope among policymakers as well. So without any further ado, over to you, Professor.
Okay, thank you, Paul, for the introduction. Very good afternoon. Very good morning, everyone. Thank you very much for your interest. Now, before starting with the presentation of the report, I would like to thank the French National Research Agency for the support of my research on NPEs, and I would like also to thank IP2Innovate for the opportunity to speak to you during such an important event. Now, the goal of this talk is to provide new evidence about the presence of NPEs in the patent market, and more generally, to stimulate discussion about the problem related to the lack of patent ownership transparency in Europe. This is an important topic nowadays, not only because NPEs are more and more active in Europe, as I will show, but also because I think that there are some simple but effective actions that can be designed in order to make the patent system more transparent. Now, the outline of the presentation is the following. Initially, I'm going to give an overview of the notice problem in the patent system with a particular attention to the implications of the lack of patent ownership transparency. Next, I will give an overview of the increasing presence of NPEs in Europe by providing new data on litigations and patent acquisition. Please note that for the purpose of this presentation and for the report, the terms non-practicing entities, NPEs, and patent assertion entities, PAEs, are broadly equivalent, in the sense that in our definition of NPEs, we didn't include university, individuals, and patent defensive aggregators. Now, going back to the presentation, in the third part of the presentation, I will present two case studies as an example of how some patent holders in Europe may exploit market and information frictions by, for example, creating German companies in the UK in order to acquire, hold, and assert patents in Europe. Finally, I will end the presentation by proposing a few recommendations to improve transparency in patent ownership. Now, according to the economic theory, patents are key to innovation as they serve a dual role, protection and disclosure. On the one hand, by granting exclusivity to inventors that can show they have been able to create something new, patents may encourage companies to make the necessary investment for innovation. On the other hand, by encouraging inventors to disclose their inventions to the public, patents may give the public access to information regarding the content of the technology protected by the patent. So the notice function is particularly important for the functioning of the patent system, since it allows for a more efficient level of investment in innovation. For example, it can reduce unnecessary litigation, or also can facilitate knowledge transfer and knowledge spillovers. The issue here is that the incentive function of patents is guaranteed by the possibility for the patent holders to enforce the patent in court. However, the notice function is only guaranteed by the transparency of the patent system. Patent holders and in general NPEs make use shell companies in order to accumulate patents with explicit aim of making it difficult for anyone to know who is the patent owner. Second, because recording a change of ownership to patent offices is often non-mandatory. The patent ownership assignment is in fact a two-step process where the legal validity of the contract between two parties is not conditioned on the effective transaction to the patent office, with the implication that the information regarding the patent ownership that is available to the public can be incorrect. Now, the problem is that the lack of patent ownership transparency has some important implications for the well-functioning of the patent system, making the patent system less balanced and effective. Among other implications, I would like to show three important factors that should be considered. The first one is related to the fact that innovators cannot easily determine the characteristics of patent landscape in which they wish to invest, thus limiting their freedom to operate and the possibility to negotiate ex-ante licensing agreements. Second, by using shell companies, patent holders may easily avoid preemptive actions. I'm thinking, for example, at the EPO, at the positions at the EPO, or even at the inter-partes review at the USPTO. And finally, another important factor to consider is that when patent defendants are small players with a low IP management skill, it may happen that these entities may be in a situation in which they have to pay multiple times to what is essentially the same company and for what is essentially the same technology. So, having said that, and despite all the problems in identifying NPEs in the patent market, in this second part of the presentation, I would like to give an overview of the increasing problem of NPEs in Europe by providing new data on litigations and patent acquisition. Data on patent litigations are provided by DARCP. The figure shows the share of infringement actions started by NPEs over the total number of infringement actions by litigation year. Now, please note that in the figure, the figure for the Europe are in blue and the relevant axis is on the left, while figures for the United States are in red and the relevant axis is on the right. Now, the figure shows that in Europe, the share of infringement actions started by NPEs has increased significantly from around 5% in the period 2010-2013 to about 30% in the period 2014-2017. In the US, litigations by NP account for the majority of all patent litigations, and since 2012 are quite stable. Now, what I would like also to say is that the litigations are only the tip of the iceberg, in the sense that various studies have speculated that unlitigated assertions are probably as much as 90% of all patent enforcement. So for this reason, the size of the patent portfolio held by NPEs could be a better indicator in order to assess the presence of NPEs in the patent market. So for our project, we have built a unique database of NPEs patent history, including filings and patent acquisitions, both at the USPTO and EPO. I don't have enough time now to explain in detail the methodology we use to build this database, but I'm happy eventually to answer any question during the Q&A time. Now, the figure shows the share of transfer patents that have been acquired by NPEs by year of acquisition. According to this data, we observe that in Europe, the contribution of MPs as patent buyers has increased significantly, rising from about 0.8% in 2007 to about 2.3% in 2014, the last year covered by the analysis. On the contrary, in the US, the growth has stopped in 2012, and in 2014, MP patent acquisition started by MPs represented about 5% of all patent transfer. Consider that part of the difference that we may observe between the US and Europe can be due in part to the fact that the European Patent Office does not report a change of ownership after the grant phase. So we think that we are underestimating the presence of MPs in Europe. Moreover, I would like also mention a paper that I recently written with Gianluca Orsatti, in which we show, by using this data, how MP patent acquisition is on average linked to a reduced use of the patent. So altogether, I think that these figures should raise an alarm for policymakers in Europe. Now, in this last part of my talk, I present the main findings of our case studies, in which we would like to show how some patent holders may exploit the market and information frictions in order to monetize patents in Europe. In the first case study, we show to which extent patent holders may use of UK dormant companies in order to hold patents, and we show the characteristics of these patents. Dormant companies are entities that do not carry out any business, are entities without any significant activity, but however are entities that can hold intellectual property. In Europe, in 2019, we find that there are 850 dormant companies with at least one patent acquired in the market. In particular, in UK, we find that 776 dormant companies are registered in 2019, so that these dormant companies based in the UK correspond to more than 90% of all dormant companies in Europe. Now, we also found that some of these companies are actually linked somehow to producing companies, are somehow subsidiaries of some producing companies in Europe. So by excluding them from the analysis, we finally end up with a sample of 224 UK dormant companies with no link with any non-dormant company in the group. Because of this restriction, we can consider the identified companies as NPs. Now, these companies are young, small, with no employees, and for this reason, they normally escape the media attention. However, some of them are international, since 15% of them have the parent company outside the UK. More interestingly, what I can say is that they have in their patent portfolio more than 14,000 patents filed in different patent offices. An econometric analysis based on European patent data shows that controlling for the technology of the patent and for the year of filing of the patent, we show that dormant companies hold patents with a high risk of being litigated and characterized by a low technological value. Now, in order to have a better understanding of the business model of the UK dormant companies for IP monetization, in this second case study, we focus in detail on an identified company which is called Dragon Green Development Balboa. Dragon Green is based in the Republic of Panama, and according to the original incorporation document, the directors of Dragon Green are also directors of other hundreds of companies. In particular, one of the three directors of Dragon Green is involved in other 927 companies. We cannot be sure, but we suspect that individuals are figureheads with no real power. The Dragon Green network consists of at least 13 companies, UK dormant companies, holding between 1 and 100 pounds in capital. 12 companies have the exact same legal address, and this address is also reported by 3,000 firms active in 2019. The Dragon Green Group has no website, has no contact address, but holds at least 15 patents. All of them are German patents, and is involved as a plaintiff in 14 litigations, always in Germany. The figure shows the complexity of the network of Dragon Green. In the picture, Dragon Green is in the center, and the dormant companies linked to Dragon Green are represented by red and green circles, and the patents are identified with squares. The figures is also interesting because it shows as Dragon Green never appears as a patent owner of the selected patents, but all the patents are held by the UK dormant companies. Now, to conclude, I would like to propose a few suggestions that I think can help to make the patent system more efficient. First of all, I think that the policy reform should not target NPEs, but in general should target the opportunistic behavior of patent holders by providing solution to patent notice failure. Second, I also think that the European Patent Office and the national patent offices in Europe should better coordinate their activities in order to make patent ownership information more easily available. And in this sense, the EPO initiative of the Federated Register is really welcome. Finally, I think that the patent law should go hand in hand with the contract law. It should permit the identification of the beneficial owners in order to rebalance the negotiation process between the patent holder and the supposed infringer. Moreover, I think that the legitimacy of the contractual transaction between the patent buyer and the patent seller should be conditioned on the effective registration at the patent office. This is because the incentive function and the notice function are equally important for the well-functioning of the patent system. So this is all. Thank you very much for your attention, your time, and I'm here for any question. Thank you very much.
We'll now have about 10 minutes of questions for the professor and for his two co-authors, Jean-Paul Ramesh Kumar and Johannes van der Pol, who helped Professor Sturzi prepare this report. And we have a couple of questions that have coming in. The first question that came in actually on Twitter was, how relevant is data over patent litigation if most companies don't have means to go to court? Valerio, maybe you could hand this to one of your colleagues, or you would want to take this yourself?
I can answer the question. So how relevant are the litigations data? In my opinion, in order to have a better indication of the presence of NPEs in Europe, data on patent acquisition are a better indicator, in the sense that it happens frequently that NPEs do not may decide to attack even European companies not in Europe, but in US, for example, because they think that they have a higher likelihood to win in the US.
Okay.
So in order to have a, can you hear me?
Yes, I carry on.
Okay, so to me, having this data is much better, even because of, as I said during the presentation, almost 90% of assertions do not pass through litigation.
Right.
So
okay.
we can really not observe what's going on in the market.
Okay, we have actually a significant question here that should be answered, I think, publicly here, from Brunet Michelin. Who funded the study? And how independent is it?
Okay, so IP2I commissioned the report, but didn't play any role, in the sense that we were given the full control over the content of the study, so the report is independent. Let me also add that the report is part of a larger project funded by the French National Research Agency, and part of the results that I've showed are based on this project. And finally, let me also say that part of the funding comes from VINO, the Technology Intelligence Platform of the University of Bordeaux.
Okay, that's great. Thank you very much. There's another question that's come in. Are there any specific characteristics in patents that are acquired by NPEs?
In general, according to the data that we have collected in the USPTO and European Patent Office, on average we find that NPEs are targeting high quality patents. They acquire however patents which are quite old in comparison to other patents acquired by producing companies. So the two characteristics are high quality and old patents.
Right. And can you give any examples of opportunistic behavior that can be targeted? For example, ways to hold the IP.
Let's say, without enter into detail, I mean, the idea is that they may acquire patents which are nowadays quite obsolete without disclosing their patent acquisition to the public, so
Right.
that they may wait for the right moment to attack the companies already producing in the market.
Okay, we do have another question here. Actually, it's about definitions. I mean, how would you define? It says NPE, the non-practicing entity. Maybe you did spell this out a little bit at the very beginning of your talk, but it is very important, the definitions. What is the difference between an NPE, a PAE, and a patent troll? Maybe you could just spell it out and then we can be done with it. We don't want to drag down the conversation too much.
In our report, we didn't distinguish between NPEs and patent assertion entities, in the sense that we define NPEs as legal independent entities that acquire or file patents without the intent of producing or selling any good or product based on the patented invention. So in the report, we didn't distinguish between patent assertion entities and NPEs. In general, as I told you before, entities which are non-producing entities actually as individual inventors or universities as well are not included in our definition, in the sense that we include in our definition only entities which have an active role as a plaintiff in litigation cases.
Right, okay.
We prefer to exclude these entities.
Yeah, no, I think that's fair. We haven't got time to go into too much detail. The definitions alone could take up 10 minutes if we allowed them. I have another quick question here. Why are NPEs and the dormant companies they use to assert their patents attracted to the UK? Is this anything to do with Brexit? Did it precede Brexit?
I'll take this one.
Please do.
The analysis in any case was started before Brexit. And a lot of the companies, or the dormant companies, existed before there was any talk about Brexit whatsoever. So the main advantages are that the dormant company incorporated in the UK, they can have directors that are themselves companies. So there's a very important part that is related to anonymity in this case. So I can start a company, have another company being the director, and they can remain completely anonymous. I don't have to pay any corporate tax while having IP inside the dormant company. Also, this company can remain dormant for a very, very long, extended period of time, which is different from other companies where dormant companies can only exist for a limited amount of time. So for these reasons, we at least suspect that the UK is a breeding ground for these types of companies.
Okay, thank you very much, Johannes. That's very interesting. I have a question in here from a journalist, from Geoff Wild from IAM. He asks, if patents are high quality and are found to be infringed, why does it matter who owns them? Would you, Valerio, like to take that question? It will have to be the last question because we are coming to the end of this Q&A. So just a brief answer, if you could, Valerio. There will be opportunity for Josh to ask that question in the press briefing after. So,
yeah.
Go ahead.
In my opinion, there is no problem at all, in the sense that when IPs do acquire high-quality patents and they help inventors to monetize their patents, or help inventors to enforce their right, I don't see any kind of problem. The problem that I see in the patent market is when they actually behave opportunistically by hiding to the public the fact that they are acquiring patents and they wait for the right moment to assert the patents in court. Otherwise, I don't see any kind of problem. On the contrary.
Great. Okay, well, listen, we're going to have to stop it there. Valerio, Johannes, and Jean-Paul, thank you very much indeed for your contributions. Stay on board because you may have questions yourself for the policymakers and others that attend for the next 2 sessions. So thank you very much. We're going to now move across to the panel to hear their thoughts on the problem of NPEs or patent trolls. In the middle section of this online event, the panel discussion, and it's going to be a series of interventions. I'm first going to turn to Jean-François Cassis. He's the director of IP for the travel tech firm Amadeus. Jean-François is going to give a broad overview of the role of patents in the innovation process and how patent abuse will likely escalate due to the coronavirus pandemic. So, Jean-François, over to you.
So thank you very much, first of all, to thank you, you all, the IP2I management, you, Paul, for addressing and helping us to express ourselves, and the European Commission also, through Melis, to be here. So I think today we are expressing a very important problem. When actually the patent system was created, some people say in Venice, some people say in the UK, but what everybody will say it was that it was done to actually foster innovation, to actually help people that take risk, and then try to protect these people through a monopoly. So patents are a very serious thing, because as you know, society normally doesn't like monopolies. When you are giving such a right, I think it comes with a kind of a responsibility. So, and this is the responsibility we are asking. How can we find that in the use of the right? So, with the companies in IP2I, and I take the opportunity to also to salute Geoff that asked the question, and I think that do a lot of work for a good patent system as well. We are for a strong patent system. We are for a strong patent system that actually allows companies to innovate, to protect their innovation, and actually also that helps them to cooperate and to participate in agreement and to exchange knowledge, and for example to foster open source. You can only give what you have. The problem here is that there are some inefficiencies in the system. The problem, as I see it, is that there are some inefficiencies of the system, like for example that are known, like for example high legal costs, and for example some very importantly, a very big uncertainty on the output of any litigation. Nobody is sure 100% on how any litigation is going to finish. Neither you can always allow yourself or this uncertainty to go on for years in a big company, because you will have management and investment blocked, and that will actually really harm the companies. So. And the problem here is not a problem of the patent system or patents being important or not. The problem is that there are some companies, as we see it, that uses these inefficiencies of the system to play and to obtain benefits which are not linked to whatever they are trying to sell or to license. This actually has been been treated and been resolved quite a bit in the United States. In the last 10 years, and therefore we have seen a litigation for patent trolls, or at least the disputes coming to Europe, looking for new landscapes, as our friends from the other side of the ocean had a bit to resolve it. And now there is a problem that it could even spread around in Europe. So it's a reality. It's a real problem that bothers companies. And as we said, we only want proportionality to apply. We only want a good patent system that is well balanced, as the MP Wolfgang was talking about, and that allows, again, the purpose of any patent system to protect the innovators, to protect the people that take the risk, and not and not to protect people that use patents that are not really for coming from any serious purpose, again, to play the inefficiencies of the system. And I will finish by saying that as we are in a period of crisis, like we were in 2008, we might actually see the problem getting bigger now, because we will have some companies divesting that are looking for fresh cash in this crisis, and so that may be tempted to divest their portfolio, and therefore will create more opportunities for this kind of events.
That's great.
That, for me, I hope
Jean-François.
I gave an idea of what it feels from a company point of view.
Now, that's great. Thank you very much, Jean-François. Thanks for that intervention. I'm going to move straight on to our next guest. He is Edmund Mangold, an IP attorney from BMW. Edmund is going to talk a little bit about the complex products and supply chains and the role of patents in those complex supply chains. Edmund, over to you.
Yes, thank you very much for giving me the opportunity to present these thoughts. As you mentioned already, we talk about the specific issues about complex products, about the supply chain in complex products, and the interrelationships between the supply chain, and finally the enforcement of patents, specifically the issue of getting injunctions by courts. So, as you may imagine, cars are extremely complex products. They integrate 10,000s of components and subsystems. Accordingly, a car is a composition of a high number of technologies, ranging from, for example, patented rubber mixtures for tires, up to a high number of electrical and electronic components, in which umpteen or even hundreds of thousands of patents may be implemented. To produce a car, typically hundreds of suppliers supply the components. Each supplier is a specialist on a specific technology. Accordingly, it's well-established practice in the car industry that the suppliers take responsibility to supply their components free of third-party rights to the car manufacturer. I really need to stress how important this aspect is for manufacturing a complex product, and I can also say that that's one of the key elements that in the car industry the balance between right holders and manufacturers works very well. And taking maybe the result in front of that, exactly that balance is a kind of stake now when we look on the further developments we had in the past years with patent enforcement, also in our industries.
Okay.
If only one single component of such a complex product as a car is accused for infringement of one patent, the patent owner may put the whole car subject to a lawsuit. Hence, each individual patent potentially becomes a heavy weapon that could result in the entire car being withheld from the market, since the patent owner may ask for an injunction at the court based on this single patent infringing component or subsystem. In other words, if one of these very small components, the patent may even concern only a very small function of a subcomponent, the value of this invention may be slightly small compared with the value of the whole car, but the whole investment for the car and car protection can be void simply because this one little invention and patent
Can anybody hear me?
the threat of
It'd be really nice
injunction
if someone could come over
which
here
is
right
caused
now
by
and answer the
this
question.
one patent. So the threat of injunction hanging over the whole car,
Am I muted?
like a sword of Damocles, the patent holder, and in particular non-practicing entities, NPEs, have a huge negotiation power, and increasingly feel encouraged to make extremely unreasonable, excessive demands for settling patent infringement lawsuits pending in Europe. Maybe that can be an answer also to the question which was raised before by Geoff Boyle. So the difference is whether you can talk reasonably about the value of a single invention and the patent, or whether you are faced with completely out of range excessive demands for settling a patent infringement lawsuit.
Edmund, we're going to have to wrap it up now. Can you just, because I'm sorry, we're going to have to be very strict with time. We are running very late on time.
Okay. One last sentence, please.
Please.
So, based on these facts and experiences in the market, it is vital for sectors like car industry producing complex products and other industries that across Europe a homogeneous proportionality principle is applied in patent lawsuits. Thank you, and sorry for taking more time.
And I'm sorry I had to interrupt, Edmund. Thank you very much. That was very interesting. Okay, thank you. Just to remind you in the audience that your questions are very welcome. Please submit them via our Twitter feed or through the chat function at the bottom or the side of your screen, whichever way you've got it configured. We're going to move to the next speaker now. His name is Maurits Dolmans. He is a partner at the law firm Cleary Gottlieb Steen and Hamilton. He's been covering antitrust standards and patent matters here in Brussels for many years. He's I'd say you wouldn't be embarrassed if I called you a veteran of this field, Maurits. He's going to give some insight into the flaws in Europe's patent systems from the front line. So, Maurits, over to you.
Thank you, Paul. Professor Sterzi showed that we see more and more firms break up patent portfolios and sell blocks to patent assertion entities. Some do this to extract money, and some do this as a competitive strategy, selling patents to patent assertion entities called privateers, and then get them to sue the competitors to raise their rivals' costs. We see also more lawsuits started by patent assertion entities, in particular in Germany in the IT sector, and with the Internet of Things to come, this will only increase. This raises concerns. It leads to excessive costs for industry for three reasons. First, German courts in particular issue injunctions almost automatically, sometimes even for patents later found invalid. That puts immense pressure on targets. Copenhagen Economics did a very interesting econometric study on this, or an economic study on this. And as Edmund Mangold explained, one patent amongst many, reading on one tiny component amongst thousands, can block an entire smart car. Second, each patent assertion entity will demand royalties without regard to what other patent owners ask. Professor Carl Shapiro showed that the result of ownership fragmentation is a royalty stack well above the monopoly price. That's economically inefficient. Third, because patent assertion entities don't make anything themselves, targets have no way to fight back with the counterclaim to lower fees. None of this helps innovation. Patent assertion entities don't innovate, make, or sell anything. So how to find a fair balance, apart from Professor Sterzi's recommendations? Using competition law is complicated and takes time, but we can apply Article 3 of the IP Enforcement Directive. Article 3 says that injunctions should be granted only if they are proportionate. That requires a balancing of interest to check whether the needs of the patent owner outweigh the harm to the defendant and to society as a whole. When the US Supreme Court did this in the eBay case, disproportionate injunctions decreased and a fair balance was struck. German courts in particular have ignored Article 3 for years. The German government is now amending patent law to require a proportionality test. The problem, however, is that the amendment proposes restrictions not allowed under the IP Enforcement Directive. It says injunctions can only be refused in, and I quote, exceptional cases of unjustified hardship, unquote. That's too strict. If that is adopted, German law will violate EU law. I'd encourage the Commission and the Parliament to insist on proper implementation of their directive. Insist that the amendment should reflect the words of Article 3, no more and no less. Thank you.
Maurits, thank you very much indeed for that. It was very clear in the discussion. I think they're bringing it back to the IP Enforcement Directive really is the common thread here. This is the call is for the European Union to actually uphold its existing rules. Let me move quickly on to the final speaker, to Patrick Meinhardt. He's going to give the opinion from the perspective of the SMEs.
Are a problem, a great problem for the industry on the one hand, and for small and medium-sized enterprises and entrepreneurs on the other hand. So I'm very happy to speak here for the biggest voluntarily organized confederation of SMEs in Europe and in Germany, because we know the number of cases in the US hit historic highs in the period between 2010 and 2016. After US patent legal system has been moderated, patent trolls turned their attention to Europe, making use of the imbalances in the European patent legal system. And whoever is targeted by a patent troll can only lose. Either pay license fee or fight a tough legal battle. However, time and money are the component that most SMEs and startups lack, and I have to say it in this way. The troll's goal is not to win the lawsuit. It is enough if the defendant buys the license for the patent out of fear. Why can't troll attack at all? There are some reasons for it, which are caused by the weakness of our patent legal system in Europe. I'll talk about 3 of them very shortly. First of all, patent trolls make use of injunction gap. The delay between infringement and nullity judgments. Aggressive patent trolls take advantage of this imbalance to sue small and medium-sized business. They demand huge amounts of money from them. These companies must then pay off in order to avoid stopping the production and costly litigation. Therefore, Europe must react to this problem by bridging the injunction gap. Nullity proceedings must be expedited. In addition, the government should increase the staff for the nullity senates. Second reason why business suffer from the activities of patent trolls is the low quality of the patents. If SMEs hold patents of low quality, they become vulnerable to patent assertion. In contrary, if the patent is of high quality, it will drive away the trolls. Therefore, European Patent Organization must improve the quality control of the patents. Thirdly, large corporations and SMEs suffer from the strict and absolute nature of the patent holder's rights to prohibit. For example, there is a possibility that the operation of the whole machine could be shut down, even though only a small and insignificant part of the machine infringes the patent. That is why our German organization BVMW, as well as European entrepreneurs, call for legislative measures to avoid unreasonable hardships while still maintaining an effective patent protection. An alternative for total prohibition could be any kind of compensation to patent holders. So it is an effective tool that will protect companies of all sizes and especially small and medium-sized enterprises. Thanks a lot.
Thank you very much, Patrick. We are running a little bit late, but I would like to open up the discussion to questions from the floor. We have a question in that is actually not addressed to anyone in particular, But we have the four panelists, and we have Valerio Sterzi, Professor Valerio Sterzi, also on board, who can also help to field some of these. But I'm going to put this question, first of all, to Edmund Mangold from BMW, because I sense that there is perhaps a hidden reference here to the car industry. The question is, would the panel care to elaborate on the situation of standard essential patents and how non-practicing entities may use these? Edmund, would you have anything to say on that particular topic?
Yes, I think I can say a few words on it. Basically, the issue of standard essential patents, of course, is a very specific issue compared to the general concept of proportionality, which would apply to any kind of IP, of course, and specifically to patents, where we talk about, in this session, we talk about patents also which are non-SEPs, where the proportionality principle is, of course, also important. Maybe specifically to our industries in the automotive industry, there is one issue we have in common with the supply chain. So in the supply chain, it is important to a car manufacturer that all patents which need to be licensed for the component are already licensed in the supply chain. And if that is done, of course, properly, which needs to be done, of course, properly for SEPs as well, then the world is okay from our perspective.
Right.
And basically, I can say what is, of course, important to us is that the licenses to standard essential patents are available to any entity in the supply chain, from the very beginning up to the car manufacturer. Whoever seeks for the license should get the license from the SEP.
Okay, thank you very much, Edmund. I would like to put the question across to Maurits as well. Maurits, I think there's a veiled reference to Daimler and Nokia. With regard to SEPs, it's the most prominent complaint there is at the moment out there, an antitrust complaint. Could you have a word? Could you say a word about SEPs in the light of what non-practicing entities are doing?
Well, we do see acquisitions by non-practicing entities of standard essential patents, and also significant assertion of these patents, of these standard essential patents, in particular in the German courts, but of course also in the UK. We see the Unwired Planet case, the Conversant case, which are now before the Supreme Court in the UK. The problem with standard essential patents is that they are almost unavoidable because for various reasons. First of all, when a standard is set and then the standard is implemented by the industry, a network effect develops. That means that everybody else in the industry is going to implement that standard as well in order for their products to communicate properly.
Doesn't that make them extremely attractive targets to NPEs?
That makes them very attractive targets to NPEs because they are essential and they are very hard to design around. And there are no alternatives for companies. Before a standard is set, there may be various ways to implement, to avoid or solve a particular technical problem. After the standard is set, all these alternatives are excluded. Now, that means that a competition at the level of the technology is completely excluded. In exchange for that, the company that owns intellectual property on a standard is asked to give a so-called FRAND promise, a promise to license on fair, reasonable, and non-discriminatory terms. And the idea is that the license cannot be refused, and the license to anybody who wants to have that license to implement the standard. And the license should be reflecting the value of the innovation, but not the value that is contributed downstream by the complex product manufacturer or the value that is created by the standard setting. Because the standard essential patent owner is rewarded by having excluded all other competition and creating a very significant volume of implementations. Now, what happens is that non-practicing entities acquire these standard essential patents, they assert them. Sometimes they try to get around the FRAND promise. The European Commission has rightly put a stop to that in the IP2Innovate case. Nonetheless, there are significant discussions and disputes about what actually is a FRAND promise. So put yourself in the situation of a manufacturer. You know that there are many standard essential patents out there. As Professor Sterzi said, you don't know necessarily who actually owns those patents. So, and then once you have implemented the standard and you're completely locked in, suddenly all these people come out of the woodwork and take pot shots at you, trying to hold you up, and effectively extracting value that is related not to the technology itself, but to the value of the downstream product. Copenhagen Economics did a very interesting game theory analysis of this. They explained that automatic injunctions in the German patent systems distort the bargaining power in settlement negotiations because the manufacturer is locked in, because they know that they are locked in, and that means that the patent owner can extract the value or the profit that you can derive from the downstream product rather than the inherent value of the intellectual property on a tiny component amongst many thousands.
Right. This gets back to what Edmund was saying as well, that one small unit, a patent on one small unit can actually hold up an entire production line of a complex product.
That's right. So the bottom line is that the problems we have identified in connection with non-practicing entities and patent assertion entities are even more of a problem when standard essential patents are involved.
Right. Okay, thank you very much. We're going to move into another question here, and it was one I think that many of us were predicting. Would the unitary patent system be a stronger additional shield for protection or a highway for NPEs? Is there anybody who would like to field that question? Jean-François, perhaps, would you like to answer that question?
Yes, the question is actually, I think it would be wrong to answer yes or no or one way or the other. It will depend. That's the easy way. It will depend the way we do it. As we said, there are these inefficiencies in the present system. So will they be corrected? Won't they be corrected? I think is not possible. Of course, to answer, I think, of course, there is a reality is that whoever in a unified system actually uses this unified system, of course, has got more leverage to negotiate. I think everybody can understand, but it will depend on the particularities. The risk, of course, is the forum shopping. The risk, of course, is the forum shopping that we open in a system where whoever is actually doing injunction will try to find the best possible place for its interests. And that could be a very problematic, as we know that some places in the EU don't have a big culture of IP, and the judiciary system is not very well trained. That's
great, Jean-François, thank you very much. Unfortunately, we are running low on time. There are more questions, but we are going to move on to the next segment of our event. We're going to have an intervention from the European Commission. Thank you very much for those questions.
Thank you, Patrick, for inviting me. Thank you also, Mr. Meller, for animating this discussion this afternoon, and thanks to everybody. I must say that I have very much enjoyed the debate so far, and I've listened very carefully to the presentation also of Mr. Sterzi. We haven't yet seen the report, but of course we will read it with great interest when it comes, because the issues that you mentioned are, of course, very important. As you know, our Commission will come up with an IP action plan very shortly. That IP action plan is one of the measures that the Commission promised to come up with in the context of its industrial policy communication in March. And recently also our Commissioner, Mr. Breton, confirmed his intention of the IP Action Plan. And why is that? Because indeed we believe that a strong but also effective and a balanced IP system is one of the key levers that we have to push for Europe's economic recovery in these difficult times. I mean, it is not difficult. I know that you're all aware that we are going through an economic shock. Going forward, we will need a lot of investments, public investments, private investments, to go forward and to find solutions to get out of the crisis. And we also, as Europe, must make sure that we harness our resilience in key technological areas. And that's, of course, where, of course, patents come in. Now, all of you have stressed already the importance of patents, yeah? And I cannot agree more. We need to harness the capacity of our companies to develop R&D and to also get the rewards they need, get the protection they need. Europe is a front runner in many important areas of technologies. Think, for instance, green technology, and that is something that we need to support. At the same time, we need to have an entire balanced patent ecosystem because, of course, we want to make sure that we push innovation through the entire European economy and that we do not only work to the benefit of the interest of a number of companies only. Now, you've been asked me to explain what is in the pipeline. What is it the Commission is working on? Again, the IP Action Plan will come, and that is where you will then find what the Commission promises to do for the next coming years. But let me give already some indications, some work that is going on. First of all, our Commissioner made it very clear, very recently, when he came to the jury committee, same committee to which Ms. Waltham belongs, we need a unitary patent. And also, I am this time rather confident that we will get it. Not before the end of this year, but hopefully before the end of next year, because the ratification process is still going on, and we look forward to the German ratification. Why the unitary patent is important? Well, it has already been mentioned this afternoon. It will cut cost. Yeah? Getting a patent protection, maintaining patent protection will become at about 6 times cheaper in Europe as it is today. That is a very, very important element. It will also reduce time and effort for patent holders to get patent protection. But the unitary patent is also a way to get more legal certainty and to get transparency, yeah? At least if we do it very well, yeah? But it holds a big promise there. And that are also important elements that have been stressed this afternoon. Why legal certainty? Well, we will get one set of rules with one centralized court system adjudicating what is a valid patent and what is not, and dealing with problems. That, in principle, should enhance legal certainty. Also, more transparency. A unitary patent is one title with one owner, with one register where that ownership is being entered into. And I also understand that the European Patent Office, with whom we are in regular contacts, is also taking steps in order to make sure that in the future, patent information becomes even more readily available and is up to date. So in itself, it should be good news. Yeah. Once we have the unitary patent, we would also like to move to a unitary SPC. Now, the SPC system is, of course, a very particular system. It is there for pharmaceutical products, veterinary products, supplementary certificates. But problems that we see currently in the patent system are also replicated there. Too many divergences because of, well, actually there we don't even have a European grant mechanism. We have only national grant mechanisms, leading to many divergences and concomitant also a problem of lack of transparency. So we hope that with the unitary SPC, we could also help overcome that. Patent rules, there is always a question also what can be protected and what not. Yeah. and that is the whole question of substantive patent law harmonization. We have already come a long way. And for the future, the main issue that we are looking at is actually questions of interpretation. We believe that our patent system is quite resilient, but we know already that going forward, we will have to look into issues again relating to biotech, where questions arise all the time. We are also, and together with the EPO, looking at issues relating to AI and patents. So this is also a development that we monitor in order to make sure that our rules evolve as our economies and our industries evolve. Now, I was talking before about the need for a balanced and an effective patent ecosystem. And that means that we are obviously not only looking at protection, we're also looking at enforcement issues. And Maurits has already said it very well. We have very good rules here in this context in Europe. We have Article 3 of our IPRED directive, the IP Enforcement Directive. Now, back in 2017, we did a whole evaluation to see whether the directive is fit for purpose still, and we concluded, yes, it is fit for purpose, but it has to be applied better and in a uniform manner across Europe. Yeah? In order to foster that, we came up with guidance recapping jurisprudence of the Court of Justice, but also best practices, giving indications how the IPRED directive should actually be applied in concrete terms. And that also covers the notion of proportionality. Now, I'm very happy to see that on proportionality, quite a lot is going on right now. We have interesting case law that is being developed as we speak in France, in the Netherlands. We have in Germany right now the legislative reform process going on. And I'm very happy also that the German government conducts this process in a very inclusive manner with a public consultation. I understand that they intend to publish very shortly on their website what could be a draft legislative proposal. Well, we're also looking forward to seeing that and see how that evolves in order to make sure that we have a uniform application of the proportionality principle in Europe. By the way, and looking forward, going back again to the unitary patent, which we find so precious, I would like to refer to the draft rules of procedure for the unitary patent because they are already online. And mind you, also these draft of rules of procedure contain the obligation to do a proportionality assessment. Yeah? A balancing of interest, a weighing of interest, taking on board potential harm that might be inflicting on either side. It is not a one-way street. It is about a bundle of elements, in the way of interest that needs to be conducted. So we monitor this, but I would say so far so good. Let's see what the future brings, because indeed proportionality is an important principle. And then last but not least, a last area that requires our attention and increasing attention, I would say, is the whole area of licensing. Yeah, indeed, patents rest on a balance. It is protection, but it is also about disclosure, so that the protection can be used by others in the interest of economic development and innovation. Licensing starts with transparency. And back in 2017, we came out with a communication specifically focusing on standard essential patents, where we made very much the case for stronger transparency. Yeah? Transparency actually in two ways. Transparency about who is the owner of patents and whether or not patents are valid. If people need to take a license, they have a right to know. They should know where to turn to, what's the address, what's the telephone number, how to reach the party, who has what patents. And then also transparency in a second sentence, which is very specific to the issue of SEPs, and that is more transparency about whether or not a patent is essential to a standard, yes or not. And in this context, I would like to refer to the fact that, as you know perhaps, we have been conducting a pilot study looking into the feasibility of a third-party system, a system of a third-party essentiality check. We have now round up the conclusions, and that study will be published shortly with some pointers of how to come to a third-party essentiality mechanism in Europe, which could be a lever to come to more transparency. Transparency at the beginning of the journey. Again, I will stop very quickly to allow also for some Q&A. Apart from transparency, there is, of course, the whole issue of FRAND. And as already has been said before, FRAND is a difficult concept, which raises a lot of emotions, if I even might say so, and a lot of divergent interpretations. Now, already back in 2017, we gave some high-level principles as a Commission, which we believe should be respected by parties when they are entering into negotiations over what can be a FRAND license. So the high-level principles we gave there, always with a view to pursue a balanced approach, an approach that can work for both sides. It is absolutely crucial that those that develop technologies, connectivity technologies, get a fair reward on a fair return on their investments. But it is, of course, also crucial that those that need those connectivity technologies can use it under fair terms and in a predictable manner. Yeah? This is key, for instance, to ensure the rollout of the IoT. On FRAND, the judgment is still out. We are following, of course, what is happening before the national courts, where many discussions are going on. We're following also what is happening in other jurisdictions. We are looking also at voluntary initiatives. Actually, the Commission itself was calling for voluntary initiatives and business sector-specific initiatives in its communication in 2017. So we're following that actively. We have also ourselves created an expert group to deepen expertise on FRAND licensing and FRAND evaluation, and hopefully the expert group will come forward with a report fairly soon, which will add also a new element to the debate. So, for SEP licensing, more transparency, a balanced approach to SEPs, not necessarily a one-size-fits-all. Solutions can vary from sector to sector, but the rules should be clear and they should be made in such a way that they are producing win-wins, coming to the benefit of the entire European economy. So that's in a nutshell the issues that we're looking at. Voilà, I suggest to stop here so that there is still some time for questions and answers. Thank you.
Thank you very much, Ms. Verhoeven. And before I open this up to questions, I just was wondering if you can give us any inkling, any idea about the time frame for the action plan. Can we expect it in weeks?
Yes. Well, the time frame is not clear yet. Okay.
Okay. Before the summer?
Our Commissioner has said soon, but I cannot give any promises about what that means.
All right. Oh, good. I would like to invite the panelists back, and if they have questions, they have a special privilege of actually asking them orally. They just need to alert me to the fact that they want to ask a question. So if there are any people on the panel that would like to ask a question, do feel free to ping me a little message, and through the wonders of technology, I will see a message on my tablet in front of me, and then I will be able to open you up for a question. But in the meantime, as I'm waiting for that, Ms. Verhoeven, I was wondering if you could say a little bit, linking back to Professor Sterzier's report. He did make, which is unusual, I think, for an academic report. I mean, he made some policy suggestions, some recommendations for how to tackle what he has identified as a growing problem, and to some extent a migrating problem from the other side of the Atlantic. But what do you think about his idea of corrective measures for people for organizations that are abusing the system and abusing the transparency? What do you think of the idea of having perhaps fines for abuse of this system?
Okay, well, thanks. Indeed, I was listening to these recommendations. I must say I'm discovering them on the spot. Yeah? And I would really rather prefer to first look at the study in its details before taking any position on this point of view. I think Professor Stadnir rightly stresses the importance of transparency. Let me remind you that the Commission itself also conducted a study. It's a couple of years ago on MPEs. The broad conclusion of that study is that actually the system as we have it in Europe is fit for purpose, is not really incentivizing the behavior of NPEs, yeah? But it did also point to the need of transparency, yeah? Now, again, as I said before, I believe that when we move to the unitary patents, we will automatically already get more transparency. Do we need to include on top of that fines? Well, that needs to be looked into. I mean, I don't want to create a system where people are penalized for trying to assert their rights in court. I mean, that would be over the top for me, yeah? So again, here, we need to see what is needed, and we need to follow a very careful and a very balanced approach, yeah? So, voilà. And on top of that, I haven't read really the recommendations, so it's difficult to react to it.
Absolutely, no. I'd like to go across to Maurits Dolmans. He has a question for you. Can we open the line up for Maurits to speak?
I think my line is open.
Yes.
Now, it's slightly outside, it's a different DG that's responsible for the horizontal guidelines, which are currently under review. They're also under attack. When you read the public comments, there are quite a number of companies, mostly STP owners and also non-practicing entities, who would like these horizontal guidelines to be changed. For instance, currently they provide for a license to all. Anybody who wants to implement the standard should have a right to implement the standard, regardless of where they are in the value chain. So they are under attack. I think the rules of FRAND are also under attack in Germany. The case law is moving away from the sequence that the European Court of Justice has set in the Huawei ZTE case, where a licensor must say, I'm offering a license. Licensee should say, potential licensee should say, I'm willing to take a license. Licensor should make an offer. Licensee should make a counter offer, and so on. They're interfering with that, and they're changing the sequence in a way which makes it much more difficult for implementers. We also see that there is an increased attention to injunctions in the area of FRAND and standard essential patents, which to me has always been very strange, because an owner of a standard essential patent has promised to license on fair, reasonable, and non-discriminatory terms, and then they go around and seek an injunction if they don't get what they want. Now, I understand full well that sometimes in negotiations both parties may be stubborn, but isn't the right solution then to set the royalties either through court or through arbitration? There are perfectly good procedures. For instance, the Article 315 of the German Civil Code allows for a rate-setting arrangement between a licensor and a licensee. So my question to you, Amaryllis, would be, would the Commission encourage that kind of rate-setting process rather than injunction? And would the Commission protect the existing rules that are in the horizontal guidelines, which in particular, the license to all principle? Thank you.
Okay, well, thank you very much, Maurits, for these two questions. Yes, indeed. On SEPs, we are working. I mean, I am working in DG GROW, as you know. But the reality of the situation is, of course, that we work across DGs. We have a whole team looking at SEPs issues. And I was mentioning two elements of, two of our pieces of work in the SEPs area, which are rather piloted by my DG. But of course, alongside this, we have the ongoing review of the horizontal guidelines, which is conducted by our colleagues in DG Competition. Now, for the review of the horizontal guidelines, the process is going on. And you will very well understand, Maurits, that this means that I cannot prejudge what will be the outcome of the review. Okay? I cannot possibly do so. So whether that will lead to a change, No change. What kind of change? It's too early to say. The process is going on. Okay? That's the first thing. Then on your second element, would I agree that there is too much focus here in the market on injunctions and on court cases? There, I must say yes, I cannot agree more. And this is also one of the lines that was developed in our communication. Actually, we did our communication in the hope to see less litigation and to see more agreements found on a sectoral basis between either sides. And that would be meaning a lot less transaction costs. It would mean a lot less hassle, a lot more predictability. And anything which can help us get into that direction, I think we would very much welcome that. Litigation is certainly not something that we seek to foster, right? Okay. Now, how to do it then exactly, whether that means creating instances that can help you ex ante assess what is a front rate, boosting, further out-of-court settlement systems. These are all elements that could be possibly on the table, okay? So once we have actually the various elements on which we are now working, the studies and the reviews, etc., then what we plan to do as a commission, have a bigger public debate on the basis of all the results of that. And in that context, of course, we can be looking into potential solutions here. I hope that's good for now.
Thank you, Mr. Hoven. And I'm afraid we're going to have to cut it short. We have reached the end of the time. Stay online because there's a final word from Kevin Prey, our chairman, after this animation. I'm sorry I've taken up your time already too much. Go ahead. Final message.
Thank you, Paul. I will keep it brief. First, I'd just like to thank our speakers and panelists and attendees for participating in this event. I think we've had an excellent discussion on ways to improve the patent system and make it fit for purpose in the digital age, trying to ensure that we're striking the right balance between protecting inventions and ensuring access to products and services for the public. The findings of Professor Sturtze's report were really interesting. They shed a lot of light in an area that I think a lot of us may not be so familiar with. It's the lack of transparency in patent ownership and how that is being exploited, particularly by certain patent assertion entities. The continued problem of PAEs migrating from the US to Europe is a sign that the imbalances exist in Europe's patent system. And allowing these imbalances to be leveraged, particularly by non-innovative entities, undermines rather than supports innovation, and it works against the very purpose of the system. We heard today from innovative European companies about their experience confirming this lack of balance in Europe's patent system. And we also heard about how many European courts issue automatic injunctions upon a finding of infringement, and in some cases even before a determination on the validity of the patent is completed. And they do so without considering if another remedy would be more important or proportionate. The leverage obtained from the threat of an injunction on a complex product can greatly exceed the economic value of any single patent, particularly when a patent covers a minor feature incorporated into that product. The threat of an injunction is especially perverse when the patent owner's true goal is to collect royalties and not to remove a product from market. Such practices discourage R&D investment, slow innovation in Europe, and are harmful to consumers. We also heard today that SMEs are affected from this undermining activity. They're particularly vulnerable as they often can't afford the legal fight. Ultimately, to protect innovation and ultimately consumers, EU policymakers need to ensure remedies for patent infringement are more proportionate and that no product is automatically removed from the market. Failing to align the remedy for patent infringement with the economic value of the patent by rigorous application of a proportionality principle encourages further misuse of the patent system. The solution lies in a more efficient and consistent application of EU law. We hope that the European Commission will show leadership and take action to ensure the proportionality requirement is applied in a meaningful way in patent enforcement by judges around Europe as required by the EU law. IP2I and IP2Innovate and its members stand ready to work on specific solutions to correct the balance in the patent system and prevent exploitation of the legal system to the detriment of Europe's digital economy. And since I know we're short on time, I guess I'll just leave it at that and hand it back to you, Paul. Thank you.
Thank you very much, Kevin. And I would just like to say a final quick thank you to all the panelists who shared their time with us. Thank you to all, and to Valerio and his colleagues in Bordeaux. And one final message to the journalists present. Don't forget, the press briefing is starting straight after this, so you have the separate login details. Log into the Zoom chat, and we can discuss. You'll be discussing with Valerio Sterzi, Maurice Dolmans, Kevin Prey, and Patrick Oliver from IP2Innovate. So thank you very much. Goodbye.